Attend the court, please. The Honorable Supreme Court of the State of New Mexico.
Please be seated. Good afternoon. This is S-1-SC-39544, Soon versus Kammann. Can I have entries of appearance, please?
Yes, thank you, Your Honor. May it please the court, Kammann from Toya Guidance and Custody Law. Representing Miley Soon, and she's a petitioner.
Great, thank you.
Chief Justice of the Court. My name is Ellie Rushmore. I am an attorney in case in New Mexico. My co-counsel is Lauren Sanders, and we represent Jean.
Thank you. All right, Mr. Montoya, it appears that you have elected 20 minutes for your argument in chief and 10 minutes for rebuttal. Is that correct? All right, you can take the podium.
Thank you, Your Honor. May it please the court. I will address the judicial admission that occurred in this case, as well as the rules of this court, which establish the fact that the opposing party, Ms. Kammann, who I'll refer to as Ms. Kammann, is not the genetic parent of the children, as well as the failure to preserve the question that she raised in the Court of Appeals and this court, that the court was required to have genetic testing in order to overcome the presumption of parentage during the marriage. And thirdly, the non-compliance with the artificial insemination statute, which requires a consent of both parents in writing for artificial insemination, where the court found that Ms. Kammann did not establish that there is a sign fighting by her. And the fourth point is the withdrawal of consent that the biological mother, Miley Soon, did when she deliberately did not want her spouse to sign the consent for artificial insemination. With regard to the judicial admission, there was uncontradicted testimony under oath that Ms. Kammann stated that she is not the genetic parent of the children. The court was absolutely under rules of court, but also the province of the judiciary. The court.
What about the statute? Section 40-11A204B. A presumption of paternity established pursuant to this section may be rebutted only on adjudication pursuant to Article 6. Doesn't say by admission, it says only pursuant to.
Your Honor, neither does it say that there can be a stipulation made under Rule 608. Rule 608 provides for a judicial admission and a stipulation.
But we have to render a decision here that applies to all forms of parentage. This isn't about, and if we were to allow two adults that purportedly are parents, one, and even if they were to stipulate lack of parentage, doesn't that ultimately, under a certain hypothetical, harm the child, rendering the child without one parent, even if they are the parent?
No, because.
Why not?
Because the legislature has decided that, very clearly, that where a genetic testing, or here the admission establishes that a parent is not the genetic parent, the court shall determine, shall rule.
But you can have a statement by both parents. Parent B is not the parent. They don't want to co-parent, whatever the issue is. And then it renders the child who has no say in this subject to one parent. And isn't all of this about protecting the child as opposed to the parents? So you could have two parents really don't like each other, don't want to be involved with each other. So they're going to stipulate parent B is not the parent.
As I understand
And the child is left with that outcome regardless of its veracity.
that's what I was going to ask. So the presumption is that there is collusion here,
Yeah.
where one parent is the biological parent and the other parent is also a biological parent.
Or not, but under this, yes, biological, and they both say, we don't want to do this together, I'm going to let you off the hook. We're going to tell the court, not genetic parent, ergo there is a stipulation, uncontested statement that parent B is not the parent.
Okay. First of all, I do want to make the point that the legislature has determined that the non-genetic parent shall be ruled and determined by the court to be not the parent of the child. So the legislature has determined.
Only if there's a test
Only.
pursuant to the court order. The court can say, I'm not going to order a test pursuant to the statute. And if the court says, I'm not going to order a test, the presumption of paternity persists.
I will address both points together. The same result applies, Your Honor, if there's a default, and there's a default provision in the Parentage Act. So if one parent, the biological parent, sues for non-parentage, or there could be other types of cases, like estate cases, and the respondent simply doesn't respond. So now what's the court going to do? And there's a default in appearance, there's a default in failing.
This isn't a default, though. You have two people colluding to say parent B, whose genetic parent, isn't the parent. And that causes, that undercuts the policy purposes behind the Parentage Act, which is to protect the child.
And in that example, Your Honor, if there's collusion, there's two ways to that can be effected. One is simply not to answer. So there's no compulsion to answer. So if there's collusion, the other parent just doesn't answer. And so the court is required, I believe, under the rules of this court, to render a judgment by default. And there's another reason. And that reason is the court can order genetic testing. But what happens if the parent says, well, I'm not going to do it?
It's called contempt.
Correct, Your Honor, but there is no genetic testing. Okay, so there's a contempt, there could be a fine, maybe there's imprisonment, but how long under a civil contempt is the court going to keep someone behind bars for failing to take a genetic test? So the point is.
So we're going to write a rule against the hypothetical genetic parent who either defaults or rejects genetic testing and is willing to go to jail until such time they are compliant. That's the rule we're going to write in this case.
No, the rule is that when someone tells the truth, that they are not the genetic parent, that the court is absolutely entitled to credit that sworn testimony with the truth, because it's the truth that is to be provided by the district court judge and by the court of justice. So the other point I will make is that claim of no genetic testing was never made before Judge Lavelle. He didn't get a chance to correct that. Neither did Miley Sue. She didn't get a chance. So if that claim, and by rules of this court, we shouldn't even be here discussing the issue of genetic testing as set forth, because this error was not pointed out at all to Judge Lavelle. There were findings there. In fact, there was, when the pleadings themselves, when the motion to dismiss was filed in the lower court, the claim was made by Miley Soon that the presumption of parentage by marriage had been overcome. And Ms. Kammann's response to that is, no, it hasn't, because there's the artificial insemination statute. So she mentioned the artificial insemination statute. She did not mention the genetic testing statute. And what she said is something that obviously is certainly common knowledge, that under oath that a child cannot have two biological mothers. So if she had pointed that out, then the court would say, okay, I see the statute. We're going to have genetic testing. And there you go. Okay. The Ms. Kammann said, well, not only did the judge commit error by not ordering genetic testing and finding non-parentage, but I wanted to advantage myself of the equitable power of the court to deny the genetic testing. Well, we're talking about a child who, children who were born while proceedings were pending. There was a separation of the parties 4 months after conception. That statute, of course, would be used for someone who had, there's a holding out, as happened in the Chatterjee case, and where this other parent, non-biological parent, had actually been a parent to the children throughout their lives, or through a very extensive period of time. So that would not apply, but the—
Well, there was no opportunity for those facts to be developed in this case because of the timing of the birth of the children.
I think the mother, the biological mother, had the right to separate. She had the right to file for divorce. And if there was not an opportunity, there's no opportunity under the new statute. The holding out provision says that you have to hold out for the first 2 years of the child's life, of the children's life. So
If there's no opportunity to do that, is that grounds for withholding or denying genetic testing?
well,
Would that,
I was talking about the presumption of parentage during the first 2 years of the child's life. So if there's no opportunity, there's no opportunity, but that's something the legislature thought through or didn't. And this is a uniform act, by the way, which has been promulgated in numerous states by the Uniform Law Commission.
Can I
But-
ask you a question before you move on with that? I'm specifically regarding 608, and the Court of Appeals specifically mentioned this in footnote 5 of their brief, where it says that maybe Ms. Kammann didn't specifically ask for the genetic testing, but she surely did mention in her brief that under some circumstances, application of the genetic testing provision might be unfair. So, I mean, do you agree that that was raised by Ms. Kammann?
No, Your Honor, I disagree. The litigant is required to do this. They're required to make the same arguments to the district court that were made in the Court of Appeals or the Supreme Court. Those arguments were not made. So what Ms. Kammann needed to do was say, hold it, Judge, rather than responding in a pleading and saying the presumption of parentage by marriage has not been overcome because of the lack of genetic testing. She says it hasn't been overcome because of the lack of finding that she had not consented to artificial insemination in writing. So what she needed to do was to tell the court, Judge, I am still a presumptive parent. That presumption has not been overcome because there's been a lack of genetic testing. Now that would, and this is part of the preservation rule, that not only gives the court the opportunity to correct its error, but gives Ms. Soon the opportunity to address the claimed error. And what does she do? She asks for genetic testing. So this failure to have genetic testing is not the fault of the court. It's the fault of the litigant. It's clear in the statute, as has been pointed out. So this matter should not be here. In addition, with respect to the lack of the writing, the Court of Appeals, respectfully cobbled together a number of different writings to indicate that, well, that there was an intent in the past for the parties to co-parent. But it doesn't even come close. The reason it doesn't come close is because scrutinizing those exhibits, and that would be exhibit A1, A2, and A5, they're all the same donor. They all have the same donor number, which is a German donor. And the last one had occurred 6 months before the insemination, which did take place in July of 2016. So
That Ms. Kammann participated in very directly. The insemination.
she participated, yes, Your Honor.
She wasn't a standby observer of the insemination.
She participated, and I believe according to the testimony, because of intimidation, okay, because the things were not going well. The uncontradicted testimony was that the parties had difficulties. They couldn't communicate respectively or effectively. They weren't understanding each other. Ms. Soon was not sure the marriage would work. There are disagreements and arguments. It's not just the
That
point.
doesn't add up to intimidation, those statements. That adds up to a dysfunctional relationship, so I want to be careful how you're characterizing the evidence. But it doesn't set aside the fact that Ms. Soon and Ms. Kammann agreed to, in the moment of insemination, to participate in that together. It is not as though Ms. Kammann was a stranger to that room or that process.
Well, Your Honor, that legislature did not choose to use the word participate.
It's called equity.
Not equity when you have a statute concerning artificial insemination. And Your Honor, what we don't want to get is to he said, she said, she said, she said, with regard to intent. Okay, that
So
we can't have.
Let's talk about intent. It seems to me, based upon whatever I've read, is that there's no issue, but that Ms. Kammann and Ms. Soon wanted to be parents. And they wanted to be the parents together. And this was exhibited on over and over and over again. Neither Ms. Soon nor Ms. Kammann ever said that they didn't want to be parents together.
I respectfully disagree, because the uncontradicted testimony was that Ms. Soon said that she did not want Ms. Kammann to be a parent in July 2016. And there was
That's
testimony.
after the fact.
Pardon me?
That was after the fact.
Well, that was the fact of insemination. That was.
Except,
That,
I mean, it's convenient to have Sunday morning quarterbacking of a series of events. But Ms. Kammann was in the room and functionally inseminated her then wife. That is a very far cry from, I want to have nothing to do with you or you to have anything to do with my children.
Ms. Soon has the absolute right of her bodily integrity under constitutional law, the Griswold versus Connecticut and other cases. She has the right of personal autonomy. She has the right of personal integrity, and she alone decides who the parent of her child is going to be, and that would be
That is contrary to the statute. It just is.
I disagree, because the statute does not provide for any withdrawal of consent for the biological parent. So if that were not the case, Your Honor,
It provides for withdrawal by the non-biological parent, which the
Correct.
non-biological parent here did not do,
correct.
did not withdraw. The withdrawal statute has nothing to do with the biological parent and provides no protection to the biological parent. So where's your evidence that Ms. Kammann withdrew consent?
Well, the uncontradicted evidence at the trial that she did not want Ms. Kammann to be the parent of her child.
No, you mishear me. The withdrawal statute has nothing to do with Ms. Soon. The only parent that can withdraw consent is the non-biological parent. So where's the evidence that Ms. Kammann withdrew consent?
As to Ms. Kammann, I don't think there was evidence that she withdrew consent, but her consent is not the only one required under the statute. It's Ms. Soon's consent, and it's
Ms. Soon does not withdraw consent to artificial insemination.
She does, Your Honor.
Not once the insemination has happened. It is done.
This was
Only the non-biological parent can withdraw that consent once the consent is given.
Your Honor, Ms. Soon can go to the facility by herself. She doesn't have to have her partner with her.
That's you're assuming there is no consent by the non-biological parent.
No, I'm assuming there's no consent by the biological parent. It takes both. This is the right of personal integrity, even in a heterosexual relationship. Each and every time that intercourse is to take place or is anticipated, that biological mother can decide not that the husband, that the partner, the boyfriend will not be a parent. So this is the absolute constitutional right of bodily integrity.
You ignore large portions of the statute, Mr. Montoya, but in any event, you've run out of time.
Thank you, Your Honor.
Are you picking me up? I'm a little bit shorter than.
Just so you'll know, we were talking about having a podium that'll go up and down in the future. So,
I can bring my own stool next time.
No, you are fine.
Thank you, Your Honor. The case before you today is unique, it's emotional, but ultimately straightforward. The Uniform Parentage Act is typically invoked in a context where one parent is attempting to hold another accountable for their children. Here, Ms. Kammann has at every turn asserted not only her right to be a parent to the twins, but her responsibility to the twins. Before this court are two separate and independent grounds upon which Ms. Kammann can establish her parentage. First, as a presumed parent based on her marriage to Ms. Soon, and the children were born within the marriage. An unrebutted presumption of marriage means she's a parent. Second, based on compliance with the assisted reproduction statutes, that she, Ms. Soon, intended to be parents, they consented to be parents, and Ms. Kammann helped perform the procedure that resulted in Ms. Soon's pregnancy.
Explain, I am very interested in it, especially with the Uniform Act, about the role of consent and then the provision of withdrawal.
Yes.
What is sort of as you understand it, the underlying policy for that very, for how long the consent lasts and then the requirement of this?
Yes. Your Honor, a large part of the legislative intent and the public policy behind the Uniform Parentage Act is to ensure that all children and all parents have equal rights with respect to one another, regardless of the marital status of the parents. And the withdrawal section addresses a dissolution of a marriage or withdrawal of consent. Now, it's particularly important.
Can I just touch on that? The withdrawal either has to happen, it's a signed record delivered to the other before insemination, before placement. And I think this is a quote, "A person who withdraws consent is not a parent."
Yes, Your Honor.
Thus, the point I am making that the person who withdraws consent at that point is the non-biological parent, because the woman who has been inseminated cannot say, "I'm not a parent." It obviates the need of the statute.
Yes, Your Honor, and two things, and related to your question as well. The withdrawal statute contemplates a circumstance where there is a non-biological parent and a biological parent. Certainly surrogacy is contemplated under this act, where a birthing parent is not deemed to be a parent. And so when the legislature created this mechanism, and it is a permissive mechanism, to withdraw consent, that person is not a parent. Here, unfortunately, it's not that Ms. Soon did not withdraw consent, it's that she did nothing.
So
And
that's
referring to-
significant to
yes.
me in this analysis.
I'm so sorry. I
That's
didn't-
significant to me in this analysis, so I need to expand on that, especially given the way this medical procedure occurs. What is the significance of that, in that it does seem odd, and the Court of Appeals outlines this. I mean, it seems like you're asking for a lot of very difficult things that occur due to a technicality, the availability of the individual. You know, you're thinking about 1,000 things other than signing a form.
Mhm.
Can you elaborate on that?
Yes, Your Honor. The statutes, when read together, the assisted reproduction statutes establish two things in order to become a parent: intent to become a parent, consent to become a parent, as evidenced in a signed writing placed before the reproductive material. That's the plain language of the statute. It is not so nearly restrictive as the district court, as it grappled with these, like you noted, highly technical, highly complex issue before it. That's the plain language of the statute. It is simply not nearly so restrictive. And both parties manifested, not only before they got married, during their marriage. They celebrated their marriage no less than 2 months before the conception. They manifested through their actions and their words and the numerous writings throughout the less than a year process that it took for Ms. Soon to conceive. That is what the statute requires, nothing more.
So there were numerous writings before the conception of this case. Mr. Montoya argues that you have to have a consent prior to each insemination or attempt at pregnancy. But as I read, and maybe I'm wrong, but 4011A704A, there's no time limit on there. It says the intended parent or parents shall consent to the assisted reproduction in a record signed by them before the placement of the eggs, sperm, or embryos. It doesn't say you have to have a consent before each and every attempt. And it doesn't say how long, once you sign a consent, it doesn't say that it expires within 30 days or a year or whatever. I mean, that's problematic, in this case.
Yes, Your Honor.
Do you have an answer?
I do think it's problematic. It simply does not stand to reason that throughout the long process, it is often a long process when somebody is utilizing assisted reproductive technology, that simply because of a missed signature on a single day at a single procedure, that a parent, both parents who have manifested throughout the process through their actions, their words, and in fact have signed writings before the placement of the material, that a missed signature, that an alleged secret change of heart, particularly in a case with an estranged spouse, a contentious relationship, many relationships will struggle. In this case, it simply cannot stand to reason, and is not in line with the plain language of the statute or the legislative intent of the statute, that a missignature on one day can undo all of the actions, words, and
You say,
parties.
you use the word missed signature.
Mhm.
But I'm suggesting to you
Yes.
that my quandary is this.
Yes.
There's no missed signature. There's numerous preceding signatures.
Yes.
I don't think.
Yes, Your Honor, I
Is there a
agree.
missed signature?
Thank you. Thank you for the opportunity to clarify that. The position that we are in is defending, right, that alleged missignature, a contemporaneous signed record. There are numerous records, like Your Honor has indicated in the record, that plainly are evidence of intent and consent to undergo assisted reproduction and become parents of any resulting children.
It does,
No, go ahead.
Mr. Montoya raises, I think, this point, which is the biological mother seems to me has the independent right, should that individual decide to go in, have this procedure done on their own. Would the rule you're asking us to announce today restrict that?
Absolutely not, Your Honor. Ms. Thune's right to have children is not in question. She absolutely has that right. She did not exercise that right here. She and Ms. Kammann married, and it's in the record that they married specifically because they wanted the protections of marriage as they sought out assisted reproductive assistance. They married, they sought out assisted reproductive technology together. They went in, as Ms. Thune testified, they went in as a married couple on July 13th. Had she intended to become a parent and go it alone, she could have. She did not do that here. And Ms. Kammann's rights, her fundamental rights, are implicated as a presumed parent under this statute. Her parental rights attach until a rebutted, her parental rights attached when those children were born in a marriage.
Would you change anything about the Court of Appeals opinion?
I believe, as you mentioned, Your Honor, Monday morning quarterbacking. There are numerous ways that this court could affirm the Court of Appeals opinion. And one of those ways is simply, the Court of Appeals stated that Ms. Kammann's parentage was unrebutted. This court could decide that that ends the inquiry. If the court is not inclined to do so, it could remand, and on remand, ensure, just as the Court of Appeals directed with some specificity for the district court, that the rules to adjudicate parentage are followed. That's the crux of the issue, not actual genetic testing, but that the rules to adjudicate parentage were followed.
The question I'll be a little less obtuse here. The Court of Appeals opinion, and correct me if I'm wrong, but this is my recollection, really doesn't spend any time with 201B5, which is weighing in on the record before it. It's subject to argument, but the facts themselves about consent are plainly before the court. And the Court of Appeals did not take the opportunity to say 201B5 answers the question. Is that a possibility here, or do you believe remand is necessary?
Yes, Your Honor, I do not believe remand is necessary if this court looks at the facts and findings already in the record, applies the plain language of the statute, the consent statutes, as you noted, relevant to 201B1, and find that Ms. Kammann consented and is a parent under the assisted reproduction statutes.
And talk to me about, is there harm in a ruling that would be consistent with what the district court concluded, in that the need for genetic testing without making a determination consistent with 608? The need for genetic testing is just not a part of the inquiry. If we're looking at all different kinds of relationships with parents.
Yes, Your Honor. There would be significant harm if the district court's determinations, both in the rules to adjudicate parentage and in the consent statute decisions. The rules to adjudicate parentage are critical under the Uniform Parentage Act. Ms. Kammann's situation is shared not only by same-sex partners, but also parents who are not able to be biologically related to their children. I disagree. Ms. Kammann disagrees with the assertion that the Uniform Parentage Act in question privileges biology and genetics. It does not. In fact, it has expanded and attempted to catch up with the changing nature of family structures. And while the law has significantly progressed, and unsurprisingly, we cannot account for every hypothetical, every change in circumstance. Applying the plain language of the statute is crucial to protect the rights of presumed parents or third parties who do not know that they may have rights under this statute.
What about Mr. Montoya's argument that the issue is not preserved?
Thank you, Your Honor. We disagree. Ms. Kammann, throughout the proceedings, and there's one technical point I'd like to draw the court's attention to. The hearing where the district court determined that Ms. Kammann's parentage was unrebutted did not happen in an adjudication hearing. So the district court made a decision on the record that Ms. Kammann's parentage was rebutted solely by the fact that she could not be genetically related to the children, and instead directed her to file a counter petition to establish parentage on the basis solely of the consent statutes. Throughout the record, Ms. Kammann continued to argue that the presumption of her parentage remained unrebutted.
And whose burden is it to rebut the presumption of parentage?
It is Your Honor, it is the party that is moving to rebut the presumption. There is necessary action.
So it's Ms. Soon that needed
Yes,
to
Your Honor.
ask for the genetic testing.
Yes, Your Honor. Ms. Kammann included record citations in her brief in chief, I believe on pages 16 and 17. Additionally, in the record proper, Ms. Kammann, even after the district court determined that her parentage was rebutted outside of an adjudication procedure, continued to argue, including in her closing arguments, that her parentage should not be rebutted. The procedural posture of this case unfortunately deprived Ms. Kammann of her ability to argue that it would be inequitable based on her actions, based on Ms. Soon's actions, based on additional facts in the record to rebut her parentage. On appeal, Ms. Kammann continued to assert that. And unfortunately, Ms. Soon continues to conflate the issue of actual testing with the rules to adjudicate parentage. It's sometimes referred in the Uniform Law Commissions Act as the legal fiction of parentage, right? No one is arguing that Ms. Kammann is genetically related to these kids. Instead, she must have had the opportunity in a parentage proceeding to show that it would be inequitable to overcome the presumption of her parentage based on the birth of the children within her marriage. Once the presumption of, I almost said paternity, pardon me. Once a presumption of parentage has been established, like I said, circumstances may arise, family structures may change in a way that one parent or the other may or may not want to have anything to do with the other parent, or unfortunately the children. It is required to seek an adjudication and rebut that parentage. That did not happen here.
Can you address Chief Justice Bacon's question to Mr. Montoya about best interest of the child inquiry? There's not much on that. How do you and your clients view the court's consideration, both at the trial court and the Court of Appeals, on on the best interest of the child, and how would that impact the examination?
Yes, Your Honor. The best interest of the children under the Uniform Parentage Act is woven throughout the statute. It is entirely about, and the public policy behind, is if there are two willing, loving, able parents who are emotionally available, financially available, and physically available, that their children benefit from those parents, from access to both parents. And so, unfortunately, throughout the proceedings at the district court, the best interests of the children were not considered until the very, very end in a motion for step-parent visitation. And the district court decided that because of the contentious nature of the relationship, and that was all, did not consider any other of factors, that, pardon me.
Go ahead.
Thank you.
I wanted to.
And so the district court's failure to properly adjudicate Ms. Kamman's parentage through the rebuttal process, I'm sorry, I realize the language is, the adjudication of parentage, Ms. Kamman's parentage could only be rebutted either through admissible results of genetic testing or proof that it would be inequitable for her parentage to be overcome. And that right there is when the court could have considered the best interests of the children.
But weren't the best interests of the children considered at the beginning of the case? When the parties entered into stipulated or agreed upon visitation, child support, and the involvement of both mothers and the twins, it was considered at the very beginning, was it not?
Yes, Your Honor. I had fast forwarded a little bit in my answer to your question, Your Honor. At the very beginning of these proceedings, Ms. Kammann and Ms. Soon not only agreed on the names of the children, whose surname would be Kammann-Soon, they established a visitation schedule that accommodated the twins' breastfeeding schedule, Ms. Soon's. Ms. Soon affirmatively sought child support. They negotiated visits. They negotiated child support, just like all parents do in a contentious custody circumstance. And the district court took all of that into account. And there are numerous places in the record, beginning at the very first hearing, I believe the March 6th hearing, where the judge referred to the parties as parents, that they both had rights as parents, and continued throughout until Ms. Soon changed her legal position nearly 8 months after the proceedings began. It simply does not stand to reason that Ms. Kammann's parentage was rebutted solely based on the fact that she cannot be genetically related to the children, or that the plain language of the statute does not, that the record and findings do not support the plain language of the statute, that Ms. Kammann is a parent, both under the presumption statutes and the assisted reproduction statutes.
So for Ms. Soon to prevail, how can she prevail given the language in 631 and 608? I think she'd have to rely on 608 and demonstrate that it would be inequitable for Ms. Kammann to have parental rights. Is that a fair reading of how 631 is the greater rule, 608 being the exception, both of which can lead to determination on parentage, and really are the only two ways that can lead to a determination on parentage?
Your Honor, I don't think that there's a circumstance, given the facts and findings in the record, where Ms. Soon prevails.
But she would either, say we didn't have the record in front of us, she would either have to say, let's have genetic testing, rebutting the presumption, and then some other fact-bound inquiry, or the court would have to go down the 608 path and go through B1 through 9, including the harm that may result to the child if presumed or acknowledged paternity is successfully disproved. have to go through all of those elements, prevail on those elements in order to prevent Ms. Kammann from having a parental relationship with the twins.
Yes,
A
Your
parent, a
Honor.
legal parentage.
Yes, Your Honor. And I believe that is a non-exhaustive list of factors as well. Which is why, as the district court grapples with this, it's so fact-specific. And here, the facts and findings simply do not support Ms. Soon's arguments.
Because we didn't even engage in 631 or 608 because the answer was, you can't possibly be genetically related, so we're gonna stop there. Is that your summary of the district court's decision-making at the end?
Yes, Your Honor. And again, I do want to draw the court's attention to the fact that her parentage was rebutted outside of the proper procedure, outside of an actual adjudication of parentage. And so we didn't even get a start in an adjudication until the court directed Ms. Kammann to file a counter petition specifically on the consent statutes. And at the parentage hearing, there was testimony from both parties, testimony from other witnesses regarding the intent of the parties to parent together, testimony that showed that they planned their life around this intent to become parents. They planned their wedding. Ms. Soon waited to get a wedding dress just in case she might be pregnant. Ms. Kammann attended all of the prenatal appointments. She attended all of certainly she attended the relevant appointment where Ms. Soon conceived the twins. And so looking at the facts in the record, we did not even get a start.
And what came of the step parentage proceeding? I simply don't know.
Ms. Kammann's petition was denied based solely on the contentious relationship between the parties. Should the district court's ruling stand on the rebuttal of parentage, such an application opens the doors to prevent marriage equality from translating into parent equality. And that is not what the legislature intended when it adopted the Uniform Parentage Act. Ms. Kammann, while the law has progressed, it has not caught up. And the act that we are looking at has been amended twice in the state of New Mexico. There's relevant case law that the Court of Appeals referenced in its decision. I do want to discuss two of those cases, Chatterjee and Lane. The Court of Appeals, should this court decide that remand is necessary? We do not believe that it is, given the facts and findings and the plain language of this, and applying the plain language of the statute to the facts and findings of the district court. But should this court determine that remand is necessary, there is some guidance from both Lane and Chatterjee that this court could provide to the district court. The Court of Appeals said that Lane was relative because it provided factors to decide, equitable factors essentially. That statute was decided, or excuse me, that case was decided 2 Uniform Parentage Acts ago, where a writing before the insemination was not necessary. So the court there looked at the circumstances of the insemination, whether a writing existed that showed whether or not the husband in that case was fully aware of the assisted reproduction. Absolutely, both parties were aware here. Both parties participated in the assisted reproduction. The second factor was that the wife knew that the husband was fully aware. Same thing here. Both parties were aware, and that there was no dispute that the husband was aware. In Chatterjee, where the court found that biology is not just what makes a family, and that it was against the public policy of the state to deny parental rights and responsibility based solely on genetics, that it was the better view to recognize that the child's best interests are served when intending parents physically, emotionally, and financially support the child from the time the child comes into their lives. Especially true when they are both willing and able to care for the child. In that case, the court in which they upheld a presumption, they looked to whether or not the non-biological presumed parent actively participated in the children being conceived with the understanding that the presumed non-biological parent would raise them. Ms. Kammann established that throughout the record. 2, whether they voluntarily expressed intention to accept responsibilities and enjoy the benefits of parenthood together with their partner before the children were conceived. That, we have that here based on testimony, based on and findings from the court below. It wasn't until 8 months later, over a year after she had become pregnant, that Ms. Soon claimed that she had a change of heart. And the third factor in Chatterjee is whether or not there's competition from any other person claiming to be the child's second parent. We don't have that here. And so should the court decide that remand is necessary in this case on the consent issue, those are some of the factors that the courts have looked to determine whether or not the statutes were complied with.
Do we need to do anything with Lane?
Your Honor, Lane was decided under the two previous versions of the Uniform Parentage Act. And while, and it has, the law has specifically changed to deprivilege biology in a circumstance such as this. So the writings in Lane conveyed in some manner that the non-birthing parent knew of the conception, of the assisted reproduction, and they agreed. It is somewhat limited in utility. There was no time requirement, and ultimately Chatterjee and the new version of the Uniform Parentage Act deprivileged biology. I apologize. I just noticed my time.
To Cabin Lane.
Yes, Your Honor. I'd like to conclude. I realize I have 17 seconds. This court could decide that Ms. Kammann is a parent here today based on the facts and findings in the record, based either on an unrebutted presumption of parentage or the fact that she complied with the consent statutes, the assisted reproduction statutes. And end the inquiry. Should this court decide remand is necessary, we urge the court to provide specific guidance to the district court who will be grappling with this highly complex issue. Thank you.
Thank you, Your Honor. There are some matters which I would argue to the court are decisive in Ms. Soon's favor. There was an April 12th, 2018 response to petitioner's reply to counter petition. So what happened was the case began as a divorce proceeding, not as a parentage proceeding. And the court allowed Ms. Kammann to file a counter petition arising under the Uniform Parentage Act. She did. Then there was a response.
Mr. Montoya, it's been represented that the court ordered her to do that, not that he allowed her to do that. To me, there's a big difference.
Well, because of the claims that Ms. Kammann was making in the divorce proceeding that she was a parent, she hadn't properly filed a pleading to that effect. The case arose under the divorce statute that says that where Ms. Kammann is seeking custody, that a non-biological, non-adoptive parent cannot seek custody unless
So
there.
correct me if I'm wrong, but as I understand what happened, the district court made a ruling that because she was not the biological mother, genetic testing was irrelevant and she could not be a presumed parent because she was not the genetic mother.
It's
And
more,
then he ordered her to file this counter or cross claim.
the court ruled based upon sworn testimony of Ms. Kammann that she was not the genetic parent. That was raised in the domestic relations proceeding. That was the divorce proceeding. Then there's the counter petition for under the Uniform Parentage Act. There's a response. There's a reply actually. And then Ms. Kammann filed a response, and here's what she says. Respondent, this is April 12, 2018, response to petitioner's reply to counter petition. And that's at a record proper 176. Respondent denies that the minute order of the court from March 9, 2018 provides that the presumption of parentage has been rebutted. In fact, it does not say that. The court has yet to rule on whether the Parentage Act Section 201A2 concerning maternity applies to respondent. So the presumption has not been rebutted at this time. Here it is. The court only ruled that Ms. Kammann did not give birth to the children and did not adopt the children because respondent signed consents for the assisted reproduction, which resulted in the birth of the children. In this matter, her maternity should be adjudicated by this court. So she, neither here nor in requested findings nor in any post-trial motion before the court did Ms. Kammann ever say, Judge, I'm still the presumptive parent and we need genetic testing to disprove that. Now, second, as to specificity, there are two statutes that I believe very clearly provide that each and every time there must be a consent for the placement, for the insemination, just like the biological mother has to consent. When you walk into a doctor's office, you consent, and she has to consent each and every time. There is, first of all, as the court pointed out, there's section 201B5. So this is a parent-child relationship is established by Ms. Kammann having consented to assisted reproduction by a woman under Article 7, which I'll get to, that resulted in the birth of the child. It has to result in the birth of the child. Here's what Article 7 says.
You're skipping right over 204.
Pardon me?
You're skipping right over 204. If the child is born, children are born during the marriage, presumption attaches. You don't even have to get to the consent issue.
Well, but I think I addressed the presumption and the failure to preserve that issue. But that's what Ms. Kammann said in her pleading was that she had signed consents to assisted reproduction. And I'm addressing the question of the court concerning, does this have to be specific for each insemination? And the answer is yes. Under section 704, it says the intended parent or parents shall consent to the assisted reproduction in a record signed by them before the placement. So putting those
Weren't
two.
the consents here signed before the placement? There are numerous consents signed before placement.
Yes,
It
but
doesn't say a consent signed before each placement.
that's what 201B5 says. It has to result in the birth of the child. So they're together. It says pursuant to Article 7, which requires a signed writing.
Still doesn't say
By both-
before each. You have signed writings prior to insemination. Insemination occurs. It doesn't say before each placement, which must result, and then each placement must result in a child. The legislature left out the word each.
Yeah.
It's more generic than that.
Your Honor, you get a resulting child with each insemination.
Not necessarily.
That takes place. Okay, if it doesn't take place, we're not here. But if it
We're
takes
going to
place,
have to agree to disagree on how that lives together. And I think that interpretation also runs counter to language in Lane.
pardon me, Your Honor.
The language in Lane that doesn't require that specificity in writing.
Of course, Elaine was 2 generations, before the statute, the Uniform Parentage Act was 2 generations before in Lane and 1 generation before in Chatterjee. With respect to the withdrawal of the consent, also, that language, which does not apply to the biological parent, I agree, and that was an error made by the Court of Appeals that said that it did, says that, again, the withdrawal of consent statute refers to specific eggs, specific sperm, specific consent that must be withdrawn.
Mr. McDoyle,
Yes.
I know I'm interrupting you, but there's a question that's troubling me, and maybe you can help me. If we rule to reverse the Court of Appeals on any of the grounds that you've asserted today, what public policy are we advancing?
What I
What's
would
the
like to.
public policy at issue?
What I would like to see, and I think that this was in a prior statute, that what we really need is guidance on what the consent is. The reason we have written consent, so we don't have an argument about intent. Okay, and so there should be court-approved forms that say what the consent consists of. The prior statute had the physician doing this. And then under the current statute, the physician no longer does that.
Because
So-
that's not modern technology. I mean, people inseminate in their living rooms with friends. It's not about a doctor being present, right?
Well,
So the
but
law has evolved for that reason.
the legislature, I believe even this court in implementing the laws could have approved standardized forms as to what the consent needs to be. So the policy, Your Honor, would be, we're very clear as to what we're doing and to what we're not doing, okay? And it has this beginning date and this ending date. And I suppose even in that instance, and it looks like I got 10 seconds, there's still the right of personal autonomy that needs to be dealt with and personal integrity. Thank you, Your Honor.
Thank you.
Counsel, thank you for your presentations today. The case is deemed submitted as of today's date. Thank you.